2/3 of us own a home. If we are wise, we pay off the mortgage before we retire. Most of us want to remain at home as long as we can, hopefully until the end. Many of us want to pass the home on to our children. In Texas, this can be done. The VA excludes your home from net wealth in determining your eligibility for non-service connected disability benefits. Texas Medicaid excludes your home in determining your countable assets, as long as you have an intent to return home. There is a box you can check on the Medicaid application. Both the VA and the Medicaid benefit programs allow you to rent out your home while you are in a long-term care facility, though any income you receive will count for Medicaid eligibility purposes. For the VA, the rent counts as income. For Medicaid, you should use a special form of short-term lease requiring the tenant to pay all monthly expenses and producing no income. You cannot pay utilities, maintenance, and repairs out of your income while you are receiving nursing home Medicaid. Either someone else can pay the property taxes, or you can defer them until your death. But the taxes due will accumulate interest at 5% per year, meaning that you may not be able to leave your home to your children after all. To leave your home to your children free of Medicaid Estate Recovery and still have control of it while you are alive, you can use either a ladybird deed, officially called a general warranty deed reserving an extended life estate, or a transfer on death deed. A transfer on death deed is always a special warranty deed. By law, your title insurance does not carry over to your children. This distinction is due to a difference which may only make sense to lawyers and title insurance companies. The grantee of a ladybird deed owns an interest which you can defease or cancel at any time. You can also cancel a transfer on death deed at any time. The grantee does not have an interest at all until you die. You might think of the grantee's interest in a ladybird deed as one which ripens upon your death, and the grantee's interest in a transfer on death deed as one which springs into existence when you pass. So, which one is right for you? A ladybird deed or a transfer on death deed? There are things to consider. A ladybird deed can be signed or revoked by your agent under a durable power of attorney. A transfer on death deed cannot. Transfer on death deeds are forms or based on forms created by the Texas legislature. Sometimes this saves money. Sometimes this creates the typical problems which arise when a non-lawyer attempts to practice law. For example, a non-lawyer may have someone who lacks legal capacity sign a transfer on death deed, mistakenly assuming that Texas Medicaid, which has paid for that person's nursing home care, will never find out. This is Medicaid fraud. It is also exploitation of an elderly person, a first-degree felony. Ladybird deeds are typically created by lawyers. If you want to keep your home within the bloodline and not risk it passing to an in-law and their children from a previous or subsequent marriage, the lawyer can create a trust to which you can pass the ladybird deed or the transfer on death deed. Both ladybird deeds and transfer on death deeds avoid Medicaid estate recovery because the home never becomes a part of your estate. Under Texas law, the Medicaid Estate Recovery Program can only recover from your estate. Which of these deeds works better for you depends on your circumstances. With the help of an elder lawyer, you can make yourself and your family at home for generations to come. We are the Garrett Law Firm, Elder Law Austin. We provide legal services to residents in Central Texas. Follow us on Facebook, watch our videos on YouTube, or visit our website, elderlawaustin.com, for more information. Those links will be provided beneath this video. Unlock your future.